What am up, though? It is your favorite auditor, Audit Dim, the one who encourages you to audit Dim. We are going over the civil code, civil procedure of the state of Illinois, ILCS 725, 735. Just wait for a few people to get in here before we proceed. Please make sure you hit the thumb up, as well as if you're new to the channel, hit the bell so you could constantly receive shadow ban notifications. Alrighty, let's get the party started. Ryan, hello there. Pi, hello there. Jenny, hello there. We're going to be flickering through the Code of Civil Procedure. As you know, it's 1 zillion pages if you were to look at the hardcovers, but we're just going to be looking at a few items here and there. Alrighty. All right. Okay. (735) ILCS 52011 2101. Generally, except as otherwise provided in this act, every action must be commenced in the county of residence of any defendant who is joined in good faith and with probable cause for the purpose of obtaining a judgment against him or her, not solely for the purpose of fixing venue in that county. In the county in which the transaction or some part thereof occurred, out of which the cause of action arose. Alrighty, here's the part I'm looking for. Public corporations, local actions, liable insurance companies. Actions must be brought against a public, municipal government, or quasi-municipal corporation in the county in which its principal office is located, or in the county in which it is the transaction of or some part thereof occurred out of which the cause of action arose, except otherwise provided in section 7102 of this code. If the cause of action is related to an airport owned by a unit of local government or property or aircraft operations thereof, however, including an action challenging the constitutionality of this amendatory act of the 93rd General Assembly, the action must be brought into the county in which the unit of local government's principal office is located. Actions to recover damage to real estate which may be overflowed or otherwise damaged by reason of any act of the corporation may be bought in the county where the real estate or some part of it is situated, or in the county where the corporation is uh, located at the option of the party claiming to be injured, except as otherwise provided in section 107, 102 of this code. Any cause of action that is related to an airport owned by a unit of local government and that is pending or after the effective date of this act, alrighty. Wrong venue waiver, motion to transfer A. No order of judgment is void because rendered in the wrong venue, except in the case by judgment, confession. All right, yada, 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 yada. There's some precise shit that I'm looking for, guys. Just bear with me. I'm going to be skipping a whole lot of stuff. We're not focusing on one particular section or subsection under this code. So we will just be scrolling in this session here. Here's a good one, though. Alrighty. Trial 735 ILCS 521101. Subpoenas. The clerk of the court in which action is pending shall from time to time issue subpoenas for those witnesses to those counties in the state as may be required by either party. Every clerk who shall refuse so to do shall be guilty of a petty offense. Well, let's see here. Examination, affidavits. All affidavits presented to the court shall be filed with the clerk. If evidence is necessary concerning any fact which is according to the law and the practices of the court may now be supplied by affidavit, the court may, in its discretion, require the evidence to be presented wholly or in part by oral examination or by witness in open court upon notice to all parties not in default or their attorneys. If the evidence is presented by oral examination, an adverse party shall have the right to cross-examine. This section does not apply to applications for change of venue on grounds of prejudice. Party need to submit lie detector. Party need to submit to lie detector. In the course of any trial or pretrial proceeding, the court shall not require that the plaintiff or defendant shall not require that the plaintiff or defendant submit to a polygraphic deception test, commonly known as a lie detector test, or require, suggest, or request that the plaintiff or defendant submit to questioning under the effect of the what's that? Theopentyl sodium, or to any other test or questioning by means of any chemical substance. So the court shall not require Alrighty. 1105 section with the changes made which have been held unconstitutional. Jury demand. A plaintiff desires or trial by jury must file a demand thereof, therefore, with the clerk at the time of the action commenced. A defendant of a trial by jury must file a demand therefore not later than the filing of his own answer, otherwise the party waives a jury. Jury demand. Challenge for a cause. Each party may challenge jurors for a cause. If a prospective juror has a physical impairment, the court shall consider such prospective jurors' ability to perceive and appreciate the evidence when considering a challenge for cause. Um, Peremptory challenges. Peremptory challenges. Alternative jurors. Each side shall be entitled to 5 peremptory challenges. If there is more than one party on any side, the court may allow each side additional peremptory challenges. Peremptory challenges. Instructing the jury. Jury instruction in tort actions. Jury instruction in tort actions. Verdict. Unless the nature. Verdict. Special interrogatories. Uh, Unless the nature of the cause requires otherwise, the jury shall render a general verdict. Within the discretion of the court, the jury may be asked to find specially upon any material question or question of fact submitted to the jury in writing. Any party may request special interrogatories, special interrogation shall be tendered, objected to, ruled upon, and submitted to the jury, as in the case of instructions. Submitting or refusing to submit a question of fact to the jury may be reviewed on appeal to determine whether the trial court abused its discretion. When any special finding or fact is inconsistent with the general verdict, the court shall direct the jury to further consider its answers and verdict. If, in the discretion of the trial court, the jury is unable to render a general verdict consistent with any special finding, the trial court shall order a new trial. Oh, that's cute. During closing argument, the parties shall be allowed to explain to the jury what may result in general verdict inconsistent with the special finding. Itemized verdicts. Motion in non-jury case to find for defendant at close of plaintiff's evidence. In all cases tried without a jury, defendant may, at the close of plaintiff's case, move for a finding of judgment in his or her favor. In ruling on the motion, the court shall weigh the evidence, considering the credibility of the witness and the weight of and the quality of the evidence. If the ruling of the motion is favorable to the defendant, a judgment dismissing the action shall be entered. If the ruling on the motion is adverse to the the defendant may proceed to adduce evidence in support of his or her defense, in which event the motion is waived. Yeah, guys, we're I'm telling you that we're going to be upscaling, we're going to be updating, we're going to be out there in the field more heavy duty. Like I said, and I've been saying, Section 4 is going to take a step up. Beyond that, not just that, I get to correct FOIA officers on more than 100 points, whether that be in writing, in person, over the phone. It makes no difference. But we also have to have also have that when it comes to the court. We have to have that knowledge when it comes to the court. Beyond that, the way to get there really is to be informed. And so that's what this channel's been about since day one. T-Dot is on site. Alrighty. Sam, hello there. Commander, hello there. I had somebody send me over an email from my channel, and they said that they were going through a foreclosure, and they were asking, what code to look up really, and I told them you have to look up your state code, civil code. So I noticed, for example, so here I noticed this section right here has mortgage foreclosure. Jurisdiction, all of that. Wrongful interpretation. May, the word may as used in the article. Oh shit, I like how they define the word may. Jason said, I can't wait for you to follow up with those places. Yeah, definitely. Jason, I definitely am. What I have to do is I have to brainstorm a little bit. I have to go through my binder, my green binder, and I gotta write it down on a new page. This town, that town, that town, and that town. Because really, no, I just gotta go back through my slips, through my checklists, and make one solid page. And maybe in one day I could go visit 4 or 5 of those locations. It's been more than 21 days, so hopefully they are in compliance. But beyond that, I'm gonna have a slip with me because I'm gonna start issuing. Well, I'm not gonna talk too much until I perform it. But be on the lookout; it's coming soon. Smitty's in the building. Quasi Smitty. Collateral. Okay, so here they define the word may. That's pretty cool. Anyway, applicability of article. So mode of procedure. Except as otherwise provided in this article, the mode of procedure, including the manner of service of pleadings and other papers in service by publication shall be in accordance with the provisions of Article 2 of the Illinois Civil Procedure and other statutes in this state, which are from time to time applicable, and the Illinois Supreme Court rules applicable to actions generally as otherwise applicable. If the mortgage lien is being but whoever reached out to me, if you're when you're going through the foreclosure, then make sure that you find your state civil code and read through your state civil code. I read through it a little bit. If there's anybody out there that's having a similar situation as him, you could familiarize yourself a little bit, but it's still good to know, all angles of the civil code, because they all work hand in hand. All these statutes work hand in hand. Declaration of policy relating to abandoned residential property. Following findings. Alrighty, that's cute. Let's see what else we have here. We're just looking through the indexes here real fast. Abandoned, occupied by mortgager, or unlawful. Alrighty. Consideration. Abandoned, architectural, real estate. Collateral. Here we go. Here's T-Dot. Collateral assignment of beneficial interest. Collateral assignment of beneficial interest means any pledge of assignment or beneficial interest in the land trust to any person to secure a debt or other obligation. Oh, that's nice. Go ahead and take a screenshot of that code. Dwelling unit. Foreclose means to terminate legal and equitable interest in real estate pursuant to a foreclosure. Terminate legal and equitable interest. Oh, that's cute. Guarantor, if I'm pronouncing it right, means any person who has taken to payment any indebtedness or perform any obligation of a mortgagor under a mortgage or of any other person who owes payment or the performance of the obligation secured by the mortgage, which undertaken is made. Land trust means any trust arrangement under which the legal and equitable title to real estate is held by a trustee. An interest of beneficiary of the trust is personal property, and the beneficiary or any person designated in writing by the beneficiary has 1. The exclusive power to direct or control the trustee in dealing with the title to the trust property. 2. The exclusive control of management, operation, renting, and selling of the trust property. And 3. The exclusive right to the earnings, avails, and proceeds of trust property. Mechanics lien. Non-record claimant. Real estate means land or any estate or interest in under land, including minerals, air rights, structures, fixtures, and other things which by custom usage law pass with a conveyance of land through not described as mentioned in the contract. Means real estate which is subject to a mortgage. Wait a minute. Mortgage real estate. Oh, that's different. Means the real estate. Okay. So, described or mentioned in the contract of sale or instrument of conveyance. Real estate installment contract means any agreement or contract for a deed under which the purchase price is to be paid in installments. Oh, alrighty. Recorder means the recorder of the county in which mortgage real estate is located is registered under the Torrens Act. Oh shit, if the mortgage real estate is registered under the Torrens Act. Woo wee! I gotta look that up. The recorder of the county in which the mortgage real estate is located, or if the mortgage real estate is registered under the Torrens Act, the register of titles of the county in which the mortgage real estate is located. Recorder includes authorized assistant or employee of the recorder. Take another digital image of this baby. Recording of instruments. Recording of instruments of the record means to present the recorder a document in recordable form, which is to be recorded in accordance with section 5024 of the county's code. Together with the required recording fee, the register of titles shall accept the filing and notices of affidavits required to or permitted by the article necessary of production of evidence recorded. All right, let me look this up real fast. Torrens Act, ILCS. Oh shit. All right, let's jump into this one real fast. DWM. Alrighty, property, Torrens repeal law. Adverse instrument means any document, instrument, or paper that adversely affects but does not convey the fee title to registered land and the validity of which is not dependent upon consent by an owner or the registered land or some person claiming by, through, or under that owner. Shit, I don't got my printer with me. I wanted to print this out right now. Voluntary instrument, registered land. Yeah, this looks like a good one right here. Okay. This was not going to be a long live stream. I just wanted to really make that announcement. Like I said, I don't want to say no names, but to whoever reached out about the mortgage, like I said, you have to locate your civil code of your state, and then you'll find the mortgage section. And when you start going through the government website of your state and look through the indexes, narrow down, and become informed. Yeah, DWM definitely. Sounds like you got a lot of knowledge, DWM. We definitely have to link up. I'm not sure if you shot me over an email in the past, but if you did, or if you did not, shoot me over one to my email, foyaauditor@gmail. And this is definitely good info. I just wanted to do a quick scan through the legislation here, and Not the first stream and not the last. Statutory judgment, unknown owner. Yeah, there's a lot of requests for relief. Yeah, this definitely has some good juice in here. Real good juice. Shake the coconut, you'll hear the juice. Lawyer, pants on fire. Lawyer, pants on fire. Alrighty, well, we're at the 30-minute threshold. Like I said, we are eligible to do a music session if applicable. Depends, man. The last session that I had musically was it was definitely not the recording night, so I had to shut it down early. Anytime I open up a music session, it's not always going to be the music night. However, we did do a reading, so we are now eligible to do a music session and attempt to see if we can create a potential album tonight. You know the theme, you know the flow for you, you know the loop. All I'm asking you guys to do is hit the thumb up. Let me give you guys some update as well. Let me light this candle up real fast. I said it in the past and I'm going to say it again. I'm going to be announcing a secondary channel very soon. Because like I said, I've been saying that I wanted to keep this channel strictly for auditing videos. Clean, clean slate. Nice thumbnails, aesthetics, channel aesthetics, and all that fuckery. The secondary channel is going to focus more on clutter. The secondary channel is going to focus more on FOIA obtainance, FOIA receivals, FOIA correspondence, FOIA everything, really. And it's going to be filled with clutter. It's going to have readings on there, Illinois compiled statutes. It's going to have everything FOIA, really. New FOIA that I'm obtaining. It's going to have a lot of, what is it called? Updates and follow up and follow throughs and all that fuckery. Like, for example, I'll chop up a segment from one of my videos and I'll say, okay, here's the breakdown, go check it out on this channel. I'm not going to give you guys the name yet of the channel until I release the channel, but that channel is going to be filled with clutter. Like I said, I'm going to have a whole lot of shit on there coming out. I might be dropping 8 videos a day on that channel, so be on the lookout for that. Even if the views are very minimal, I still want to put that knowledge out there because I know I got a good batch of people that are always wanting to be in tune. So I'll make sure I give you guys the station. I'll announce the station so you guys could definitely tune in. Oh, really? DWM. Sometimes it goes through the spam folder, and you know what? I really gotta give you guys a new email as well, because the FOIA auditor and all my other emails, they got spammed with a lot of ads and shit. So I'm definitely gonna do that. But anyway, probably gonna transition this into a music stream. Refresh your browser. The one who encourages you to audit them.